Okay, good day everyone. Welcome back to our course, The Law on Sales. This is the fifth installment of our video lessons. And I am your coach, your moderator, and your professor, Attorney Lyndon A. Maceren. Today we will discuss conditions and warranties, which are found in the Civil Code. So this topic are provided for in the Civil Code, specifically Articles 1545 to 1547. So first topic would be condition. So when a contract contains a condition and the condition is a suspensive, the non-happening of which would not constitute a breach, but it extinguishes the obligation. So condition, again, to recall, it is a uncertain event in the future. So if that uncertain event will not happen and the obligation is subjected to it, then it will extinguish the obligation. However, in a contract of sale, when a party in the contract promised that the condition should happen or the condition must be performed, then the non-performance of the condition would be treated as a breach of one party. And if there is breach, then it would amount to indemnification of damages. So the guilty party will be liable for damages. Let's go to warranties. What are warranties? These are statement or representation made by the seller contemporaneously and as part of the contract of sale, having reference to the character, quality, or title of the goods, and by which he promises or undertakes to ensure that certain facts are or shall be as he then represents. So there are different kinds of warranties: express warranties and implied warranties. So express warranties are statements or affirmations made by the seller. So to the character, quality of the or title of the goods. So for instance, when a seller is promoting his product and his product is a motor vehicle, let's say a motorcycle, and he affirms in his statement or in his sales advertisement that his motorcycle runs in water and not with gasoline. So that kind of statement or affirmation is an express warranty, especially if the buyer is induced to buy the subject matter or the motorcycle because of that affirmation made by the seller. So there are four requisites of an express warranty, meaning they should all be present. First requisite, that it must be an affirmation of fact or any promise made by the seller relating to the subject matter of the sale. So in our example, the affirmation was that the affirmation of the seller was that the motorcycle that he was selling runs on water, not on gasoline. So, and then the natural tendency of affirmation or the promise is to induce the buyer to purchase the subject matter. So that kind of statement will induce the buyer to buy the motorcycle. Imagine a motorcycle that runs on water. And the buyer, third, the buyer purchases the subject matter, relying mainly on that affirmation made by the seller. And the fourth requisite is when breach is committed, then the seller is liable for damages. Okay? So again, when there's breach, it would result to indemnification of damages. So that is as far as express warranties. So express warranties may be contained in the contract of sale, stated in the contract of sale itself, or stated or affirmed by the seller by way of sales talk or um, promoting the product. Okay, implied warranties. So these are warranties which are not agreed upon. So, but these are, according to the law, it works by operation of law. So these are deemed included in all contracts of sale, whether the parties are actually aware or not, or whether they were intended or not. So implied warranties are present because by operation of law. Okay. So the first implied warranty is the warranty that the seller has a right to sell the product. So this refers to the consummation stage, since in this stage it is where the seller is required to have the right to transfer ownership by way of delivery. So if the seller has no right to transfer ownership to the buyer, then this warranty is breach. Also, this warranty is not applicable in judicial sale or foreclosure sale, when it is the sheriff who is foreclosing and selling it to third parties, or in auction sale, or in mortgage or pledge. So mortgage or pledge, when the mortgagee, when the mortgagor or the pledger fails to pay the loan, so what will happen is that the chattel mortgage, or the thing that is being pledged, will now be subjected to auction sale. Okay, the second warranty or implied warranty is warranty against eviction. So this is implied, automatic by operation of law, unless there is a contrary provision which is stated in the contract. So warranty against eviction is happened when ownership is transferred, and then the buyer shall enjoy the legal and peaceful possession of the thing. So meaning the buyer actually takes possession of the thing. Then suddenly the buyer is evicted, whether in wholly or partly, from the subject matter of the sale. And the buyer is evicted because there is a final judgment, meaning there's a court decision. So court decision serves as law in our jurisdiction. They are part of the laws of our land. So the buyer can not deny what is being ordered by the court. So the basis of the eviction is because there is a right prior to the sale, or an act which is imputable to the vendor. So meaning there was already a court case before the sale was made, because it's a prior right, no? And the seller has been summoned in the suit or in the case for eviction. But then it is now the buyer who is affected, no? So in the case, it was the seller who is the party defendant. And during the execution of the case, the court's judgment, then the buyer is affected. Or it could take place when the buyer is made as a third-party defendant through third-party complaint brought by the buyer. So what is the liability of the seller in case of eviction of the buyer? So in case of total eviction, so it is acronym as VICED. So easy to remember, no? So the seller will be liable for the value of the thing at the time of eviction. So when the time of eviction happened and the buyer has already made improvements to the thing, like he has already constructed a house, then the value of the thing would be at the time of eviction. So it would now include the improvements, which is the house, no? Number two, income or fruits of the thing. If the seller has been ordered to deliver them to the party who won the suit. So if it's part of the decision of the court that the seller or the buyer will, the seller of the thing will have to deliver the income or fruits. Third, the cost of the suit. So because there's a case and the case is not free, no? There are charges. So the seller will be liable for that. And fourth, the seller will be liable for the expenses of the contract and of course damages and interest if the sale was made in bad faith. For partial eviction, the seller will be liable to enforce the vendor's liability for eviction. So the buyer will have the right to enforce the vendor's liability for eviction. So all of this here also the same, no? Vice. And the buyer can demand to rescind the contract. When, if there is no appeal, and there's no appeal needed, nor a need for the buyer to resist eviction, because such right already accrued. Now it is enough that the aforementioned requisites are complied with. So warranty cannot be enforced until the requisites have been concurred, no? So all the requisites are concurred here. These are the requisites. The buyer has been evicted in whole or in part, or there is a final judgment, and the basis of eviction is a prior right, and the seller has been summoned in the suit. So if these are all present, then these are the right of the buyer, no? To enforce the vendor's liability, which is viced, and to demand rescission of the contract. Thirdly, letter C, the buyer, the subject matter applies to judicial sale. The remedy is, it applies to judicial sale, meaning there's a court order. Then the judgment debtor, who is the seller, would be responsible for eviction unless otherwise decreed in the judgment. So the judgment debtor is the seller. And then fourth, the vendor or the seller is not liable for eviction if adverse possession had been commenced before sale, but prescriptive period is completed after the transfer. So meaning if the transaction or the contract of sale, before the contract of sale was made between the seller and the buyer already knows that there is an adverse possession, meaning somebody is already possessing the property. It has already commenced before the sale. But prescriptive period is completed after the transfer. There's a subject to prescription. Then the rights of buyer when deprived of only part of the subject matter, so this is partial, but would not have bought such part if not in relation for the whole. So the buyer is entitled for cession and mutual restitution. So if there's recession, the parties are bound to restore the things. No? So if the case of the buyer will now return the goods and the seller will now return the price. So another warranty or implied warranty is the warranty against encumbrances. So what are different types of encumbrances? So these are the non-apparent encumbrances. So non-apparent encumbrances, these are servitude, no? Servitudes, which are not mentioned in the agreement, like for instance a right of way. No? There are properties which are located uh, in the back of the subject matter of the contract, and then the subject matter of the contract, or the property which is subject matter of the contract, is the one which is near the highway, and there are properties with no access to the highway, so that's an encumbrance, no? Because soon or in the future, those properties behind the subject property which is for sale will ask for right of way. So if this is the highway and this is the subject matter which is uh, this is the property which is subject matter of the sale, and there are properties located here, there's no access to the highway, so in the future this property is located here will ask for right of way from the owner of this property, and this property is the subject of the sale. So that is encumbrance. So in case of future suits or filing or claim for road right of way or easement of right of way, then the seller is bound to make good of that warranty. Yeah? So requisites, it's an immovable property sold and is encumbered with non-apparent burden or servitude not mentioned in the agreement. So there is no mention in the contract of sale that this property is subjected to a servitude, no, or an easement. And the nature of non-apparent servitude or burden is such that it must be presumed that the buyer would not have acquired it had he been aware of the servitude or the encumbrance. No? This is not encumbered meaning mortgage. No, this is not. This is encumbrance. No, easement or servitude. No? Because if property is subjected to easement of right of way, the property who's asking for right of way is the dominant estate, while the property uh, is the property who has been claimed to be who is near the highway, and the owner of the other properties behind that property. So difficult to describe, no? Because we're always okay. Now the the dominant estate will be asking for an easement of right of way from the servicing property. So that is why it's called servitude. No? Then when breach of warranty exists, meaning the seller did not inform the buyer that this property is subjected to easement of right of way or a certain servitude, then there is breach of warranty. So buyer may ask for rescission or indemnity of damages. And the warranty is not applicable when non-apparent burden or servitude is recorded in the registry of property. So meaning there is already a claim for easement or servitude, which is already registered with the recorded in the register of deeds. No? Meaning it's annotated in the title. So the buyer is already aware that there is an easement. But instead, despite of the notice, he still pursued in buying the property. So there is no breach of warranty in the case of the seller. So unless there is express warranty that the thing is free from all burdens and encumbrances, then despite the record written in the register of deeds, then the seller is still bound. No? So if you have seen a deed of absolute sale, there is sometimes there's excluded in the bottom, the seller warrants that this property is free from all burdens and encumbrances. So like that. So in case there is a filing of or claim filed in the future by a third party, then the seller is guilty of warranty for breach. So that's the third warranty, the warranty against encumbrances. The fourth implied warranty is warranty against hidden defects. This is defect on the property which is being sold. No? So this applies both to movable or immovable properties. So here's the seller does not warrant patent defect which is already known to the buyer. What is being warranted here or guaranteed? It's that it has no hidden or secret defects. But if the defect is very patent or clear or visible, patent means clear or visible, no? Then it is not included in this warranty. So caveat emptor meaning buyer beware. So this applies only when the defect is hidden. So again, it applies both to movable or immovable subjects. Then the nature of hidden defect is that it should hinder or render the subject matter unfit for the use of which it was intended or should diminish its fitness. No? So unfit for the use of which it was intended or should diminish its fitness. And thirdly, third exception, had the buyer been aware, he would not have acquired it or would have given a lower price, no? Because of the defect. So warranty against even defects. So when the defect is visible or even if not visible, but buyer is an expert by reason of his trade or profession, then seller is not liable. So for instance, the property is the subject property is immovable, I mean real property, a land for instance, and the buyer is an expert in land. He is a real estate consultant or real estate assessor or a real estate broker, then he's an expert in the field. So in this case, he must know the laws assume that he knows the defect, even if it's not visible, because the law presumes that he knows. So therefore, seller is not liable. And then the obligation of seller for breach depends on whether he has knowledge of such defect or not. So when the seller is knowledgeable of the defect and did not inform the buyer, then he is liable for breach of warranty. But when the seller also did not happen to know the defect, of course he is unaware that there is a hidden defect, then there's no way for him to inform the buyer. So he is not liable therefore. So if seller is aware, then seller should return the price and refund expenses of contract with damages to the buyer. We're talking about hidden defects. If the seller is not aware, then seller should return the price and interest and refund expenses, but no damages, because damages is applicable only if the seller is in bad faith. Another scenario when the buyer may elect between withdrawing from the contract or demanding proportionate reduction of the price with damages in either case. So the buyer has two options, either to withdraw from the contract or demand reduction of the price plus damages. So damages in either case, withdraw the contract plus damages, or demand proportionate reduction of price plus damages. So applicable to judicial sale, except that judgment debtor is not liable for damages. Okay, so if you happen to buy a property which is a judicial sale and there is a breach of the warranty, which is the hidden defect, then you can either withdraw from the contract or demand proportionate reduction of the price, but without damages, so no damages. Then action to prescribe 6 months from delivery of subject matter. So this is the prescription period, which is 6 months from the date of delivery of the subject matter. So in case the hidden defect is on animals, it is called redhibitory defect. So even in the case of professional inspection, but hidden defect is of such nature that expert knowledge is not sufficient to discover it. So it's called redhibitory defect. So animals who are experts on animals, of course the veterinarian or the professional zookeepers, but then they are, in some instances, they will not be, their expertise is not sufficient to discover the hidden defects on the animals. So if vet or veterinarian fails to discover through ignorance or bad faith, he is liable for damages. So the sale of animals on teams, like 2 or more, that's why it's called animals on teams. When only one is defective, then only one is redhibited and not the others, except when it appears that the buyer would not purchase the team without the defective one. Okay, So this applies to sale of other things. So animals at fair or public auction, so there is no warranty in this case, no warranty against hidden defects. Animals at fair or public auction. Sale of animals with contagious disease is void. Sale of unfit animals is void if use or service for which they are acquired has been stated in the contract and they are found to be unfit for such purpose. So if you purchase a carabao and it's stated in the contract that you're purchasing it because you're needing it, the carabao, to plow your rice field, and then upon bringing the carabao in your rice field, it does not know how to walk, or it can walk but it tires immediately, dali ramaluya. So that carabao is unfit for the purpose. So in this case, it is avoided. So prescription on this case, or the animals, is 40 days from the date of delivery of the property or the thing to the buyer. And if the sale is rescinded, then animals will be returned in the same condition as when they were acquired, but the buyer shall answer for injury, loss, if the loss or injury was due to the fault of the buyer. The buyer may elect between withdrawing from the sale and demanding proportionate reduction of the price, of course with damages in either case. Specific implied warranties in the sale of goods, and these are the warranty as to fitness and quality. So this is another warranty, which the seller must make good. So what are the requisites? Warranty as to fitness and quality. Requisites: the buyer makes known to the seller that the particular purpose for which the goods are acquired, and it appears that the buyer relied on the seller's skill or judgment. So say for instance the buyer stated for his purpose that he needs a van in order to use it for sending his children to school. So in that case, the seller then applies his judgment or skill. He is a seller. He's a salesman of cars. So so he should know. And the goods are bought by description from the seller who deals in goods of that description. So thirdly, in case of sale of specified article under its patent or trade name, there's no warranty unless there is a stipulation to the contrary. So if we're talking about trade name, like if I want to buy a Toyota van, so there's no warranty unless there's stipulation to the contrary as to their fitness or quality. Then as to measure of damage, the difference between the value of the goods at time of delivery and the value they would have had if they had answered to the warranty. So that is the damage, the value at the time of delivery and the value they would have had if they had answered to the warranty. Okay, there's another kind of sale, which is the sale of goods by sample. Here the seller is a dealer of goods of that kind. There is an implied warranty that the goods shall be free from defect rendering them unmerchantable, which would not be apparent on reasonable examination of the sample. Yes. So if the seller gave you a sample that I'm selling this one. Let's say, for instance, the sample. Let's say shumai. We're talking about food, no? Shumai. So one sample or three samples. So in those samples, the seller already warrants. There's an implied warranty that the goods, if the buyer will order, the goods that he will deliver or the shumai that he will deliver will be of that same quality, no? Same quality as that of the sample. Okay. So effects of waiver. We're talking about now waiver. What's a waiver? A waiver is the abandonment of a right, where a party abandons his right to claim or right to be reimbursed. Any kind of right. If you abandon your right, then you are waiving. No? So in this case, it's the warranty that you are waiving. No? So the buyer here waives the warranty of the seller against eviction. So in this case, the parties may increase or diminish implied warranty against eviction. So diminish because there's a waiver, or they can increase. But the effect depends on the good faith or bad faith on the part of the seller. Yes. So if the seller is in bad faith and there is waiver against eviction, so that waiver is null and void because the seller is in bad faith. No? It's clear that he is extracting a waiver from the buyer because he knows that in the future there will be claim that the future of the buyer will be evicted, that in the future the buyer will be evicted from the property. So if the buyer has no knowledge at all of the risk, then made general renunciation of warranty, meaning he is waiving all his right, or a general waiver. So it is not a waiver but merely limits the liability of seller in case of eviction. So pay value of subject matter at time of eviction. So here the waiver did not specifically states that I am waiving my the warranty against eviction. So it's just a general waiver. So meaning all kinds of warranties has been waived. It's not specific. Then when the buyer with knowledge of risk of eviction, so this time he has knowledge that he be evicted, assumed its consequences and made a waiver. Oh. In this case, the vendor will not be liable. So this is applicable only to waiver of warranty against eviction. Okay. Then the waiver is to a specific case of eviction. So it wipes out warranty as to that specific risk, but not as to the eviction caused by other reasons. Okay. So there's a specific case of eviction and it is being waived. The warranty is being waived by the buyer. So if there is another case that will spring against the seller, then that waiver does not apply. No? So only to a specific case. Applicable only to a specific case. So let's go to waiver against hidden defects. So if there's a waiver and if it has stipulated, it has been a stipulation exempting seller from hidden defects, so that will apply. Now if the seller is not aware of hidden defects, then the loss of the thing due to such defect will not make the seller liable. But if the seller is aware, so the waiver therefore is in bad faith, making the seller liable. Now we talk to the buyer's option in case of breach of warranty. Here, the buyer's option in case of breach of warranty. So there are different warranties, implied warranties and express warranties. So these are the buyer's option. Number one, first is to accept goods and set up breach of warranty by way of recoupment in diminution of extinction of the price. So meaning recoupment means some to reduce the price, no, or extinct the price, meaning no more prices, you know, lower the price. So he can accept the goods, and then there's a breach of warranty. So give me reimbursement. Recoupment is similar to reimbursement, no, or compensation. Buyer may also accept the goods, this is another option, and maintain action against the seller for damages. So the first option is to set up the breach of warranty, then meaning file an action and then file for reduction of the price or extinction of the price. Third, refuse to accept the goods and maintain an action against the seller for damages. Fourth, rescind the contract of sale and refuse to receive goods, then return them when already received. Okay, so if the goods are already in the hand of the buyer, so he must return them. So when are the instances when the buyer, when rescission by the buyer is no longer allowed? No, this happens. The buyer is no longer allowed to rescind the contract if the buyer already accepted the goods, knowing the breach of warranty without protest. So he knows that there is already a breach of warranty. So this applies to all warranties, no, express or implied. And he did not protest. So rescission can no longer be allowed. Or if he fails to notify the seller within a reasonable time of his election to rescind. So from the time he rescinded, he did not inform the seller that there is a breach, that he committed a breach of warranty. No? So immediately when you know that there is a breach on the part of the seller, you must notify him. Then file rescission. Thirdly, another option is when he fails, or when the buyer is no longer allowed to rescind, if the buyer fails to return or offer to return the goods in substantially as good condition as they were in at the time of the transfer of ownership to him. Yes, because in rescission, the buyer and the seller are bound to restore the things to the other party. So in the case of the buyer, rescission therefore demands restoration of the thing to the seller. So if he fails to return or offer to return the goods substantially in good form or good condition, then rescission can no longer be allowed. Okay, so now we will discuss extinguishment of a contract of sale. A contract of sale may be extinguished on the grounds of general extinguishment as the same as a contract, no? Any kind of contract or obligation. So if there's payment or performance, then contract of sales is extinguished, except for the warranties, no? If the subject matter has been lost without the fault of the seller, then the contract is extinguished. It's always without the fault of the seller. or even with his fault, but no, it should be without the fault of the seller, and the thing is specific. Then condonation or remission. So this is forgiveness of the thing, forgiveness of the debt. Then confusion or merger of rights of creditor and debtor. So the rights of the debtor and the creditor are merged in one person. So the same person now is the debtor and the creditor at the same time with respect to the same obligation. Then there's compensation. Compensation meaning set off. Innovation, changing the subject matter, changing the person of the debtor, and changing the person of the creditor. The annulment of sale, annulment of the contract, or cancellation of the contract, then rescission of the contract, and fulfillment of a resolutory condition. So when the condition is resolutory, so meaning it is demandable at once. So once the resolutory condition is fulfilled, then it extinguishes the obligation. Then another, lastly, is prescription. No? So like in redebitory warranty against hidden defects in animals, which is redebitory, then it prescribes the right to claim for breach or damages is within 40 days from the date of delivery of the subject matter or the animal. And that's it. Those are the important matters to the topic of condition and warranties in the law on sales. So keep on studying, keep reviewing. If you're not sure of what I'm talking about, you rewind the video lesson and then listen again, you know? Or refer to other books like the books of Hector de Leon, you know? Because what we're doing now, we are summarizing all the articles of the Civil Code. And keep on studying because knowledge is power. And this is your host, Attorney Lyndon Maceren. Email me or chat me at my MS Teams if you have any questions, clarifications, or suggestions. So see you again next time. Bye for now.